All rise. The Court of Appeals Division 1 is now in session.
Good morning. You may be seated. Okay.
Cool.
It's cool in here. We are here today on our case number 1 CACV 150298 and 0345, State of Arizona versus Garul. Each side is allowed 20 minutes, as you know, for your argument. The appellant may reserve any amount of time you'd like to use in rebuttal. If you do decide to reserve some time, you're in charge of keeping track of your own time, because the clock of the podium will reflect the total amount that you have remaining from your 20, including what you may have decided to reserve. We record these proceedings, so when you approach the podium for the appellant each time, we'd appreciate it if you would give us your name and the name of your client for a recording. We have read the briefs, and we've studied the record in these cases, and we've also discussed the case in our conference. So with that, Mr. Murray, you may proceed.
May it please the court. My name is Stanley David Murray, and I'm the attorney for the appellant, Alexander Garul, who was the respondent in the lower court proceedings. I'd like to reserve 5 minutes of my time for rebuttal as well. With all the Title 4D cases that the state has, I was kind of surprised that they didn't have a methodology to deal with this specific fact situation, where you have one father with multiple children and multiple mothers, and all of the mothers aren't before the court at this particular time that the modification is being heard. And so when the state made its analysis, its calculations, it initially came up with $400 owed to one of the parties, which was Monica Carvalho, and $200 owed to the other mother, which was Denise Wolford. But then the state determined that because of the self-support test, there would be a zero award of child support. So because the state didn't have a methodology in place to handle this situation, the commissioner decided to use his own methodology, which we think was incorrect, both legally and factually. So I'd like to start out with the self-support reserve test. And I've always wondered what the self-support reserve test was for, because in all the 30 years that I've been doing family law cases, I've never seen it applied. But in this situation, it does apply. My client does not make enough money to financially support himself. And the self-support reserve test under Guideline 15 is mandatory. And if I could read the language from the very first sentence. In each case, after determining the child support order, the court shall perform a self-support reserve test.
Which they did in this case. It was done.
They did, yes, under the worksheet.
So the shall prepare, it was done.
Right.
Okay.
But the purpose of applying it is to determine, as the sentence reads on, to verify that the non-custodial parent is financially able both to pay child support and to maintain at least a minimum standard of living. With this child support order, my client is not able to maintain a minimum standard of living.
So is it in the best interest of the children to have no support from their father? Is that your argument?
My argument is under the self-support reserve test, he cannot pay child support.
How do you jive that with the case law that we have that's long established that a child is entitled to the support of two parents? It seems to me like those are in conflict if you're telling me that the child is entitled to the support of two parents, but in this case, it's going to limit the father to actually direct him to pay, so we're just going to say that it's in the best interests of the children, that they not receive support from one of the parents. Is that right?
It's in the best interest of all the children, not just the children before the court. And so my remedy, or my suggestion, what the court should have done when determining that under the self-support reserve test, these three children before it were not going to get any child support, it should have deferred this matter, stayed it, and ordered a consolidation with the other cases so that all the children could be before the court. Yes, I understand. My client does have an obligation to pay child support.
But it's not all the children. It's 5 of the 10 children. Because the children that he adopted and the child that he had with his current wife, they're going to get the benefit of his income, right?
Right. He's legally responsible to support them because he adopted them. So they come into the equation as well as the other children.
And whose duty was it, whose job was it, responsibility, to make sure that all the wives were included in this? It certainly wasn't the court's, was it?
I think it was the state's obligation. Under Title 4D, they have an obligation to collect child support that's fair and just and appropriate.
But as you said,
So-
we have no rule on it at this time. That's why I'm asking, whose responsibility was that?
Well, my client offered to do it, actually. He offered to pay $150 a month on a temporary basis until he could consolidate these cases. It's in the record where he made that suggestion to the court. But the court plowed ahead and made its own calculation of child support.
Thank you.
So yes, under the self-support reserve test, for these 3 children that were before the court, yes, there was no child support to be paid because of the self-support reserve test. But the court should have determined, I can't do that, it's not fair to the other kids, so let's get everybody in here and let's do a consolidated case, and then we'll calculate the child support. So that's why I'm asking you to reverse this order, because it doesn't treat all the children equally.
What the state suggests in its brief, or says in its brief, is that when the self-support reserve test equates to 0, the child support award of 0 is not automatic, but in that event, the court needs then to look at the parent, at the other parent,
Custodial parent.
and do the same self-support reserve test with the other parent, and says that in this case, that would have been 0 too. And so what's
think
to
that-
be done in that case?
Yes, Your Honor. To answer your question, that self-support reserve test has a 2-part analysis, I would agree. And if there is any money left over after you apply that self-support reserve test, like the difference between his income and that $903, and if that's less than the $180 that was calculated, then the court has the discretion to apply that second part of the test. But if it's 0, that means my client can afford to pay child support because of the standard of living. He's not being able to meet that. So there's no reason to do that second part analysis because there's no difference between the self-support reserve amount of $903 and the gross monthly income, the adjusted gross income.
Mr. Murray, why shouldn't we find that your client, the state has suggested that you waive the argument or invited error. I would call it maybe judicial estoppel, where your client said I could pay $150 a month. Court ordered $175 a month. Why shouldn't we find estoppel or waiver or invited error?
And I thank you for asking that, Your Honor, because I came upon that invited error doctrine in the Matter of Thorn case, which I've learned that if you take a position in court and you argue a different position in the Court of Appeals after the trial court has adopted your position, then you're judicially estopped, you've invited error, you can't appeal it. My client did not make a position or take a position to improperly calculate child support and come up with the number that the court came up with. He offered that as an option to the $0 figure that the state had initially
So hang on.
calculated.
I'm sorry. So we're clear. Are you saying your client's position, your client's position was he was willing to pay $150? So your client's position was not that the court should enter an order for 0.
He was offering that as a settlement offer, a Rule 69 type agreement, if you will, Your Honor, rather than taking a position that that's what the court should have ordered. And now he's challenging that order on appeal. Actually, in his petition, he was saying it should be reduced to $190, I believe, in one of the cases. So that was a position he had took, and that wasn't adopted by the court either. And
So
remember,
the difference is 150 to 175 as opposed to something or nothing.
right, and that 150 again was just temporary, so that he can get all the other cases consolidated and have an actual true calculation, if you will, that would treat all the children equally.
Is anything preventing him now from bringing all the women in? And I don't mean to make that sound horrible, just the wives, the several mothers, excuse me. Is there anything preventing him now from following through on his plan, bringing those people in and getting an accurate distribution between the incomes of each individual mother and the number of children they have?
No, sir, and that's what he intends to do. But he needs a calculation as to what the child support is for these particular 3 children. That's why I'm asking you to vacate that.
But if he's bringing in the mothers of all 10 children, if that's
Mothers of 5 of the children.
5 of the children, okay, then they're going to be looking at what the child support numbers are based on income at that time.
Correct.
The numbers out of this mean nothing.
Well, the numbers out of this were improperly calculated, and when they do the calculation, they have to include past child support paid, which is at $175 for one of the mothers and $350 for the other mother. And what we're saying is it should be at zero so that we can start at a basis where everybody's income is treated the same. And to tell you the truth, I don't know how the court's going to do this. Supposedly, maybe they can average the incomes. I've seen that done in one of the cases, out-of-state cases, where they consolidate the cases and average the income to come up with a number. But we want to get this 175 and 350 award taken care of, get it erased so we start at zero for everybody concerned.
I suppose in a perfect world, you might figure out, do the calculation for each of the 5 children separately,
Right.
and
That's
then
what I thought.
reduce it by the proportion. Reduce
their
it by a
income.
percentage. That's the proportion of his total income to the total amount owed in some fashion.
And again, I'm surprised there's not a methodology in place either by the state or by the courts. The other issue I wanted to address, too, was the calculation itself of $175 per month per child. Again, that was based on percentage, as the court is aware. And we believe under the Breivik case and the Pearson cases, that is an inappropriate methodology because it only considers the father's income. We have a shared income model in the guidelines. So just to consider one parent's income is not proper under the law.
Are you saying that the court didn't do the whole analysis considering the income of the custodial parents?
It didn't consider the mother's incomes when it calculated 50% of the gross monthly income, which is another error because the court can only garnish 50% of the take-home income under 33-1131 and the Fuentes case. So there's one error there, and then they, again, only considered the father's income. Another error that occurred was the retroactivity date. We raised that as part of the issues. And again, if I need to address the waiver issue, that was raised in the petition that my client filed. So the court had before it the issue of when to make this child support award effective, and it should have been made effective either June 1st or July 1st of 2014, rather than March 1st, 2015. The tax exemption?
So,
Excuse me?
okay. Yeah,
Under 25-327A.
Yeah.
And is that not modifiable by the court?
It's discretionary, and the court could have made that determination, but it's supposed to show good cause. And the only reason the court said was because of the equitable situation, which wasn't explained or any good cause shown.
The court announced that at the hearing.
Yes, it did.
Okay. Was any comment at that time about, hey, wait a minute, Judge, we filed this back in March?
It was in the petition itself, Your Honor. I don't know if there's any authority that says, well, you've asked for it to be retroactive to the date you filed your petition, 1 month, the first day of the full month after you filed your petition. Then the court rules against that. I don't see any authority that says you have to stand up and object and say, wait a minute, I asked for it to be way back then. And my opposing counsel didn't cite any authority for that argument either.
The notion is by asking for it in his original petition, he made his assertion about what the effective date should be, meaning the default rule.
Right. The issue was before the trial court, and it was denied. So
Okay.
that's
Well,
why
it
we're
was denied orally by the court at the hearing.
Yes, sir.
Okay.
In its ruling. Another error was the tax allocations, the tax exemption allocation. I cited to the Ballerman case, which is a memorandum decision, true. Under our new rules, any memorandum decision after January 1st, 2015 is persuasive to this court, and we think that case is dispositive of the issue that the court has to make the exemptions allocated based upon the adjusted gross incomes of the parties proportionately. We're not asking for attorney's fees, but Ms. Wolford is, and we'd ask the court to deny that request. First of all, you don't have sufficient information. There's no affidavits of financial information for the court to determine financial disparity. Yes, my client does earn more than Ms. Wolford does, but the court also has to take into account living expenses, and that's why we have affidavits of financial information to show both income and expenses, so the court can make a better analysis as to the financial disparity. Also, in the reasonableness issue, I think my client has been reasonable in pursuing this appeal. I don't understand why Ms. Wolford needed an attorney when the state is essentially proposing the same arguments or positioning the same arguments as she is making now. So we don't think it was reasonable for her to retain an attorney. Unless the court has any other questions for me, I'll take a seat and save my time for rebuttal.
Thanks.
Thank you, Your Honor.
Good morning. May it please the court. My name is Joanne Falgett, and I'm representing the Department of Economic Security in this matter. Mr. Daniel Riley is also here representing Ms. Wolford, and we have agreed to divide our time, hopefully approximately equally, so I'm going to try to stop at about 10 minutes.
Are you going to divide the issues too?
Somewhat, yes. Mr. Riley has expressed an interest in mostly handling the deviation issue, and so I'm going to focus my argument on the waiver, invited error, and tax exemption issues. Also, the state does not take a position on attorney fees for the parents, and so if he would like to address that, he will. However, I'm willing to answer whatever questions the court may have. That said, the court does not need to even reach these issues about whether the methodology used was proper. This was a very clear case of invited error on the methodology by which the child support was calculated. Father said, he was directly asked by the trial court at page 12 in the transcript. The court said, "Sir, what should I do? 0? Leave it as it is?" And he replied, "No, I'm not saying 0. I mean, I'm willing to go down. I mean, like, until I can actually get hers modified, and that's what I'm trying to do." And on the next page, he even suggests an amount. The court says again, "What do you think I should do, sir?" And he says, "I mean, to go down, I mean something. I mean, it was actually like I told her out there, I'm willing to pay $150 each kid." To me, I thought that was fair. So he suggested to the court that the court not leave it at 0, as the strict application of the guidelines would have suggested, but that instead the court award child support in the amount of $150 per child. He also suggested a methodology that the court award the same amount for each child and not go through the complicated perfect world scenario of calculating the support for each child and trying to prorate it somehow. That would have been further complicated, not just by the 5 mothers in this case, but also by the fact that some of those mothers had additional children with other former spouses or current spouses, and that adds another layer of complexity to figuring out what's actually fair in terms of providing child support. So the court took, I think, a very reasonable, equitable position and took Father's suggestion that it award a per-child amount of child support that would be reasonably affordable for Father to pay. Now, how did it get there? The most that Arizona law allows anybody to garnish is half of their disposable income, not net income as alleged in the briefs, but disposable income. And that is defined as the gross income minus legally required subtractions. So things like Social Security would count, things like contributions to a dependent care account would not. Those are voluntary. So the court took Father's word for it about what his income was, $3,500 a month, divided that in half. Now, the court was not saying this amount is going to be garnished. The court was saying, here's a reasonable approximation of the amount of disposable income you have, half of your income. We're going to divide that among the 10 children. 5 of those children are residing in his household, which results in half of his income, 1/4 of Father's income being paid out as child support. That's entirely reasonable. And additionally, I would point out that that self-support reserve test was applied after the court had subtracted, or at least on the worksheet that is attached to the order, the court had subtracted an amount to account for the child support or the support that Father was providing that was not court-ordered, those 5 children residing in his house. The court was not required to do that. Under guideline I believe it's guideline 6D, it says that the court may adjust the gross income downward to account for non-court-ordered support that is being provided for children of the obligor, but is not required to.
Was the court then trying to initiate this $150 per child equalization, if you will, of child support with the idea that the other mothers would be back before the court and they would be modified as well?
There is some suggestion of that in the transcript. The court does say to father, asks why did we not, file petitions there as well. One of them apparently lives in Flagstaff, and so there was some
Out of
complication.
Maricopa County, right?
Yeah, and so there was, and one in Pinal County. So apparently it was maybe a little more complicated to get everybody in front of the court than might otherwise have happened. But certainly, father has the option, the ability to file petitions to modify in those cases as well. And the indication was that he planned to do so.
So the court was basically starting the process of an equalization of child support
Right. And the court said, I have
for the court.
Right. I have these children before the court. This is the only thing I can do anything about, and so that's what I'm going to do today. Try to equalize it. And again, the amount that father is required to pay out is totally, for these children, is $525 a month, which is, way less than 1/4 of his income. I mean, when you look at what his income actually is, $3,500 a month, and he's paying $525 a month to support these 3 children, that seems entirely reasonable. I think that the court adopted his suggested method. Let's do a per child amount that is doable for me, given that I have 10 kids. And let's set it, he suggested 150. The court ordered 175. I would also point out that in his initial petitions to modify, he requested that Walford's support be set at 191.64 and that Carvalho's support be set at 290.75. So the amount that the court awarded was actually 175 for Wolford, so a little bit less actually than what he had initially requested. And the amount he awarded for Carvalho was $350, which was a little bit more than what he had initially requested. But the overall effect was it's approximately what he requested. This is what he asked the court to do, and the court did it. And now he's here on appeal trying to convince this court to change that. And there's no reason for this court to even address whether the merits were correct. Now,
Is Mr. Murray correct that the self-support reserve test should just, and I don't mean to misquote him, but it should just take care of all these issues and the answer should be 0?
no. And again, I believe Mr. Riley's going to address that in more detail, but I'll be happy to just give
Well,
you
I don't
the...
want to take your time on something if it's
Okay.
not if it's not addressed.
Happy to answer the court's questions. But basically, no, the self-support reserve test is, as pointed out in Mr. Riley's brief and in our brief as well, it's a starting point. You do this analysis, and if the amount that you have left after applying the self-support reserve test isn't enough to cover the child support, it says the court, quote, may reduce the amount of child support down to that amount. So father is arguing that if the amount is less than 0, then nothing should be paid. But there's no conceptual difference between saying, okay, he owes $900 and he's only got $800, so we're going to make him pay $900 anyway because we're not required to reduce it down to the $800, or saying, well, it's negative $100, but we're not going to reduce it. We're just going to go ahead and leave it at 0 or make him pay $100 or whatever. So the point is, there's no conceptual difference. That it's not mandatory to reduce it based on that self-support reserve test. That's what triggers the court then to look at other factors, such as the overarching purpose of the guidelines to serve the best interest of the children. And I believe Judge Orozco pointed out that it would not be in the best interest of these children to have father paying 0 support for them. To the extent that father has 10 kids, he needs to do what he can to support them. Maybe he doesn't get that same presumptive minimal standard of living that people that only have 1 or 2 children on his income might have. Maybe that self-support reserve test needs to change just a little bit, and he needs to go ahead and adjust the standard of living for all 10 of the kids is going to have to go down a little bit in order that it's fair for all of them, because otherwise you're going to end up with these 3 children getting nothing and other children getting much, much more. And so I think the court did the best that it could under the situation to craft an equitable solution. The main point, though, is these arguments were invited. They were waived when he failed to object when the court ordered this at the hearing. And in addition, They were waived and invited error. The court doesn't even need to go there. Just real quick on the tax exemptions, because I see that my time is almost up. He didn't even object. The court said, I assume that father will object regarding the tax exemptions. The guidelines allow the court to give the tax exemptions to the other parent, all to one parent, if there's a history of non-payment of support, or if the parent that otherwise would be entitled to them would not get a benefit from them. The court made findings regarding both of those things, saying that because father has 5 children in his home, he's going to get those tax exemptions, and that it was only fair then to allow the mothers something to offset the reduction in child support. And I'm going to stop there because I believe Mr. Riley would like to have some time. Thank you.
Thank you.
May it please the court. My name is Daniel Riley, and I'm appearing on behalf of appellee Rachel Wolford. And I'll apologize beforehand. I'm fighting off a cold. I'll try to keep my coughing to a minimum.
Just cough in some other direction.
Understood, Your Honor.
Oh, okay.
I'll turn towards Mr. Murray. And I'd like to start. Exactly. I'd like to start by addressing the issue of the self-support reserve test. With respect to appellee, I believe he's confusing the mandatory calculation of the self-support reserve formula with a discretionary application of the results of that formula. As Judge Jones pointed out, the mandatory calculation portion was done in this case. In fact, it's done in every case that when a child support worksheet is filled out, because it's part of the worksheet. The worksheet will calculate that. The guidelines are very clear that once you perform the calculation, the application of the result of that formula is a discretionary step. If it were mandatory, as appellee argues, you would expect to see words in the guidelines like will or shall or obligate. Must. Instead, you see words like may. The word may appears twice. In fact, once it's underlined to emphasize the nature. And if that alone were not sufficiently clear, the guideline then states the court has discretion whether and in what amount the child support order may be reduced. So there can be no serious dispute that the application of the result of the self-support reserve test is a discretionary step. Here, the trial court calculated the guideline child support amount for my client at $180. The self-support reserve test formula resulted in a figure of 0. At that point, the trial court had discretion to enter a child support order within the range of $0 to $180, and that's exactly what the court did. The court entered a child support order of $175, a slight reduction from the guideline amount. Appellant's argument seems to have changed from his opening brief. In his opening brief, he argues that it is a non-discretionary test, that the guideline amount must be reduced anytime the self-support reserve test results in a lower amount. Today, he seems to be arguing that no, it's only non-discretionary if the self-support reserve test results in 0. So, in other words, he's arguing for a principle in which, to use a hypothetical, the trial court could find the guideline support amount in a case to be $500 and calculate the self-support reserve formula, and it comes up with 1. At that point, according to appellee, the trial court would have discretion to enter a child support order between $1 and $500. But if the obligor in that case made just $1 less a month, suddenly the trial court has no discretion and must now enter a child support order of 0. This is an interpretation that simply has no support in the text of the guidelines. It's an interpretation that exists only in appellee's own mind. There is nothing in the guidelines that supports this notion that there is a bifurcated approach to the application of the self-support reserve test in which the trial court loses the discretion that is very clearly noted if the self-support reserve test results in a figure of 0. Even appellant in his reply brief notes that a child support order of 0 in this case would be, and I think the word he uses is harsh. I can think of a lot of adjectives to describe it, but we could stick with harsh. In addition to being harsh, I think it's also insupportable. There is nothing in the text of the guidelines that would support this approach. Now, because this interpretation is not supported by the text of the guidelines, and because the trial court found that Mr. Wolford's income is more than twice that of my client's, we've asked for an award of fees on appeal. And the two issues that the court looks at when deciding whether to award fees are, of course, the financial resources available to both parties and the reasonableness of the positions asserted by both parties. My client's income is less than half that of Mr. Garul, and his position on the self...
Evidence of that in the record?
Yes, Your Honor.
Okay.
It's in the child support worksheet, the parties, their incomes are indicated there. In addition, his interpretation of the guidelines with regards to the self-support reserve test, it's simply not reasonable. There is nothing in the guidelines that supports this notion that the trial court loses its discretion when the self-support reserve test results in a figure of 0. So for those reasons, we would respectfully ask that the trial court's ruling be affirmed and that Ms. Wolford be granted attorney fees on appeal. And if you have any questions, I certainly would be happy to address those.
No. Thank you.
Thank you.
May it please the court, Stanley David Murray again for the appellant, Alexander Garul. Let me take the points that were raised in the arguments presented by opposing counsels. Again, the invited error issue. My client did not suggest to the court that he should take half of his gross monthly income, divide it by 10 among the children, and come up with $175 per month. He simply offered $150 as an option to the 0 award that would have applied. It is discretionary as to whether the court wants to include the expenses which are attributed for the children that are living in his residence. And the court did that. So the issue is not before the court as to whether it should or should not have been included. The court also applied that attribution to the mother for the children that she had in her household as well. All of the cases are in Maricopa County, by the way, except for one that's in Pinal County. And to answer a question the court had before, my client did approach the Pinal County Court for modification, and he was advised of a telephonic oral argument that he did not attend because he wasn't notified. So I don't know if there's a res judicata issue there or if he can still get that consolidated with the Maricopa County cases. On the support issue, the state argued that the client is only paying $525 per month of his gross monthly income, but she fails to mention the other child support obligations of $1,207 per month for the other children and $1,464 for the children in his household. That adds up to about $3,200, and his gross monthly income is $3,500.
Well, in all fairness, he's getting benefit of he's getting a partial benefit of the monies that are being paid for the 5 kids that are in the household.
Well, that's where the discretionary factor should have come in. The child court should have considered whether the mother of those children is also contributing to the support and either reduce the father's option in that regard. So, again, an abuse of discretion issue would be the court included all of the $1,464 when technically it should have considered whether the mother was supporting those kids as well and reduce father and come up with a more accurate calculation for the child support in this case. On the tax exemptions, there was no evidence in the record to suggest that father would not get any benefit. The court simply said, I'm going to give the mothers the exemptions because I've reduced their child support. That's not the proper analysis under Guideline 27. It has to be based on the proportionate sharing of their adjusted gross incomes.
Was he in arrears?
He was in arrears, but he was paying $50 per month, and there was no testimony that he was behind on both current support and the arrearage payments.
Wait, on the payments.
Right.
He's clearly behind on arrearages.
He has arrearages because they made a retroactive award going back 3 years when they initially made the child support calculation. But he's been paying $50 per month under that $244 and $464, whatever it was he was paying.
So are you saying that that the worksheets didn't have evidence of what his adjusted income was vis-a-vis the adjusted income of the other mothers? of the mothers?
No, Your Honor, I'm just saying that there was no evidence that he was behind on his arrearage payments. We're talking about the tax allocation.
I'm sorry, I'm talking about one sentence before that where you're making the point that the court shouldn't have just seemingly arbitrarily granted the moms the tax exemptions without looking at who could benefit from them.
Correct. There was no analysis made in regards to whether father did or did not receive a benefit. He certainly asked for the benefit, so I'd imagine it was of a benefit to him to have those tax exemptions. And it's also an incentive for him to be keeping up on his child support payments and the arrearage payments because you get a tax break for doing that. And under the old rule, the old order, he was receiving, I think they were sharing on one kid, and then on the other, he got one of the children all the years, and then they'd alternate for the other child. Definitely a good tax advantage there for somebody with his income.
But you're saying the court didn't, the court assumed he was the court probably assumed he was filing a joint return with his wife, and together they were claiming 5 exemptions, and the court assumed that was pretty much all he needed.
Well, I don't know if I can assume that from the record, Your Honor.
But that's probably what the court did, is what you're saying, arbitrarily without carefully looking at really what is your adjusted gross income and what is your adjusted income.
Correct. They didn't do that analysis. Instead, it simply said because I reduced the mother's income or mother's child support, I'm going to give them all the tax exemptions. And again, that's not the proper analysis. What is the purpose of the self-support reserve test if not to determine if a parent can afford child support? And yes, I agree, it's a harsh result that these 3 children got 0, which should have prompted the court to say, wait, I can't make an order here because this isn't right. I can't say it's fair for these kids to have $0 while the other kids are getting $1,207. So stop, consolidate the cases. This is a unique situation. This is how we have to deal with these things because the guidelines, in effect, don't apply to this situation. We have to make an analysis that takes all the kids into account because that's the fair and equitable way to do that. And so,
But isn't it difficult where a court has a petition in front of it, it's obligated to proceed with that matter, and no one's talking about bringing in other parties?
no, I think the court can, under its own motion, order a consolidation. And in fact, Father mentioned that
But
he
what
would
you
do it.
consolidate is cases.
Right.
Are you saying order him to go out and serve and bring in the other parties and then consolidate those matters? Is that what you're saying?
Yes, because he doesn't want the father to get away without having to pay any child support. The only fair way to do it is to get everybody in here. Father, go get the parents. Go get the mothers. All right, that's all I have, Your Honors. Thank you very much.
Thank you. Well, thank you to all of you for your argument and your briefing. We'll take the matter under advisement and issue a decision in due course. In the meantime, we'll stand in recess to allow the folks for the next case to come on up. Thanks.